Well, I think AIG is just it's a symbol. I mean, it's the sort of, tip of the iceberg of a much larger problem of wealth, flowing to a small number of people, even though the productivity and the ingenuity of America is really due to quite a large number of people. And I think the current debate right now is how to engineer a set of rules that are far more fair with respect to the average American. I think one of the things that we face as a society, especially in the light of new technologies, so we've seen tremendous potential for the internet in terms of organizing people, engaging them, bringing them into participatory democracy. The difficulty, I think, is in trying to use all that energy in productive ways to solve long-term problems in our society. And I think one risk of the technologies that we have is that it tends to accentuate or advantage the reflexive portions of our democracy rather than the more deliberative portions of our democracy. And what our founding fathers thought, the basic system of democracy that they crafted, it was one of representative democracy, in which there would be a filtering of ideas and a gradual working out of the arguments. We don't have as deliberative a system as we really need for some of the real long-term challenges. And so I think for people who are concerned about democracy, the quality of our discourse, the quality of our deliberations, as much as the inclusivity of it in terms of how many people are engaged, those are both really, really important things that we have to focus on. Conservatives have, I think, been remarkably successful in using language about strict construction of the Constitution or originalism as a way of reading the Constitution to try to reduce constitutional interpretation and adjudication more generally into something formulaic and mechanical that you can hold judges accountable for. I think that's nice in theory, but the reality, as every judge really knows and every lawyer really knows, is that the job of courts really involves fundamentally acts of judgment, especially in the hard cases. And how do people come at their judgments? Well, I think in our system, they've come at it through a variety of ways that over time represents the gradual accretion of precedent, of principle, lessons learned from experience, and an awareness of the evolving norms and social understandings of our country. And I think that to say that all we do is we look at the text and we read the words literally, or all we do is you look at the text and ask how did the people in 1789 or the people in 1868 understand it, that I think misses an entire range of experience that the nation has itself learned and that judges can rightly take into account in reading legal principles and legal texts. So I would hope that the Obama administration would appoint judges who are broad-minded in their view of the kinds of sources that are legitimate to take into account in reading, especially the Constitution, but broadly legal texts of all sorts.